Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. To my right and your left is Justice Suk-Young Shin. To my left and your right is Justice Rachel Hershfang. We will be the panel hearing both of the cases that are on the hearing list for argument this morning. Both are civil matters. We are familiar with the procedural history, the factual background in each of the sets of briefs. You needn't remind us of all of that. We will have questions for you. Each of you has 15 minutes of time to argue, and there is no rebuttal. If you reach the end of your time before you reach the end of your argument, you may rely on your brief for whatever remains. And of course, if you reach the end of your argument before you reach the end of your time, there's no need for you to continue speaking. The first case on our list for hearing is case number 2022 P753, the City of Somerville versus the Building Code Appeals Board. This is the city's appeal. Mr. Shapiro, you may begin.
May it please the Court, good morning. My name is David Shapiro, and I represent the City of Somerville. There is one critical issue before the Court. The issue is whether a certificate of occupancy was required for an alteration to a building where there were significant renovations to the structure. I have three main points for the Court. One, the Mass State Building Code amendments do not conflict with the International Building Code, which is the base code from Massachusetts regarding the structural alteration section. The second main point is, assuming no conflict, we then look to the International Building Code. Under the plain language of the International Building Code, structural alterations do trigger a certificate of occupancy. And my third main point is that the error was harmful error. Before I get to my first point, I would note for the Court, Record Appendix Volume 2, beginning on pages 56, ending on page 64, you'll see photographs of the before, the during, and the after construction, just to give the Court some context of the actual project. Turning to point one, there was no conflict between the Mass...
Before you get to that first point, I do have one background question on something that is not within the four corners of this appeal, but it seems to touch on it, and that is as I read the original exchange of correspondence between the building inspector and the property owner, there seemed also to be a question about the compliance of the property with special permit conditions under the Zoning Act and the zoning ordinance, rather, and the board's decision specifically excluded any view on the applicability of zoning considerations. Where does that stand, and why is that not part of this case?
It doesn't. It's not part of the case because the Building Code Appeals would ultimately rule.
They don't have jurisdiction. I understand that,
right.
But if there's a question about outstanding noncompliance with zoning special permit conditions, then the temporary certificate of occupancy wouldn't issue for independent reasons, right?
Exactly, and that was my point below in front of the Building Code Appeals Board, that because there were still conditions to be verified and to be looked at by the building inspector.
I understand that, right. but so this may not matter, right? I mean, I understand that this is a siloed, separate, independent consideration, but as a practical matter, is there a set of independent reasons why the building permit, or is that resolved? I'm sorry to go outside the record, but I'm just trying to figure out where we are.
Yes, Your Honor. So in order to get to your, I think, the critical point, in order to give a occupancy certificate, the building inspector is looking to zoning to see if it meets zoning. So in this particular case here, where the zoning is part of what's reviewed by the building inspector to determine whether to issue a C of O, that's why it becomes relevant to this case. Because if they were outstanding, and that's part of the harm of the error that we're alleging in this case, is because had the trial court...
But that doesn't make the decision by the Code Appeals Board wrong so far as it goes. It just affects whether they could get a temporary certificate of occupancy or not.
That's correct.
Okay.
What is the status now of, is there a certificate of occupancy?
No.
There is
The building
not.
is currently being occupied with no certificate of occupancy in violation of the state building code.
And what about the fines? What's happened to the fines?
The fines were originally a lot higher we actually reduced the fines to $58,000, and there's an appeal that the property owner has filed as to those fines that's being stayed, essentially, by the city until we get a ruling from this case.
Are the fines accruing daily?
No.
Or?
No.
Okay, so it's been capped at 58,000?
Yes, yeah. Once the appeal was filed, at that point,
Okay.
you know, there's no valid reason to give.
Sorry, I didn't mean to get us all sidetracked, but all of this is background, helpful background.
Sure.
So please
Yes.
continue with your argument.
Absolutely. There was no conflict between the state mass amendments to the state building code and the international building code regarding structural alterations. The Building Code Appeals Board even acknowledges that there is no conflict in its brief. The mass amendments essentially supplement but don't conflict with the international building code. We do agree that if the only code that applied in this case was the mass state building code amendments, that there would not be any requirement for a C of O. It is the language of the international building code which governs, and that's what we need to look to in this case. Under the international building code, the plain language of it says that there are three separate aspects that trigger a occupancy certificate by the building inspector. One, alteration. Two, relocation. Three, change in occupancy classification. The language states, no altered area of a building and no relocated building shall be used, and no change of occupancy classification of the building or portion thereof shall be made until the code official has issued a certificate of occupancy. Under the plain language of the code, an alteration in and of itself would trigger a certificate. If the language had said...
The board, of course, as you know, seized on the use of the conjunctive "and" to suggest that all three triggering requirements, and you've said that leads to an absurd result because then only when a building is relocated would there be any requirement for an occupancy certificate. And we will hear from the board's counsel what she has to say in defense of that view.
Right, yes, Your Honor. Just very briefly on that point, if it had said no tennis shall be played and no basketball shall be played and no golf balls shall be used unless you get permission from the Recreation Department, I mean, obviously, you don't need to play all three sports to trigger a certificate of occupancy. It just makes no sense under the plain language of the code. Now,
what role does the commentary to the code play as an interpretive tool?
Yes, I'm glad you asked that, Your Honor. The Building Code Appeals Board suggests it plays no role. I'm going to give a cite to the court. It's Sachs versus Dissinger, 488 Mass 780, at page 785, where it basically states that even though it's not officially adopted, which it has not been, yet the court still looks to the code commentary as useful guidance to analyze.
Yeah, but it's not binding.
No, absolutely not binding.
And we, of course, traditionally defer to an administrative agency charged with the enforcement or interpretation of its own.
That's correct, Your Honor. Traditionally, if there's plain language, then the Building Code Appeals Board cannot abdicate the plain language. But to the court's point, if there's an ambiguity, then you would give deference to a reasonable interpretation of the code by the Building Code Appeals Board. In our view, it's unreasonable. It just makes no sense that if you, and this is an example I think I mentioned in my brief, if you have a three-family house, residential, you convert it to an auto repair shop, you've changed the use, changed use occupancy classification, but you don't move it. Under the view of the BCAB, even assuming there's an ambiguity in the regulations, which we don't think there is, it just makes no sense. But to Your Honor's point, to Chief Justice Green's point, yes, you do give deference typically to the Building Code Appeals Board in this case, I understand that. But that only applies if there's an ambiguity or something is unclear in the regs. If the regs are plain language, they can't abdicate that under the case law cited in my brief. If I can move on quickly to the harmful error component of it. Had the court properly found there was no conflict, it would have analyzed the IBC section. The IBC section is plain what it says. A different result would have obtained. As Justice Green had mentioned at the beginning of the argument regarding the special permit conditions, that's part of the argument of the harm. because had it properly been analyzed by the trial court, there were outstanding special permit conditions that have not been satisfied, and they still have not been satisfied.
Well, I'm sorry to go outside of the record, but I was kind of surprised to hear you say that there's still no certificate of occupancy for the property, putting aside, of course, the question of whether it's required. It seemed to me from the briefing that there was agreement among the parties that it was desired whether or not it was required. Does the absence of one now mean that there are still required conditions outstanding, or does it have to do with this lawsuit, or is it some other thing?
Well, there are outstanding conditions. There's an issue, number of bedrooms. I'll get to a specific example. Number of bedrooms is actually referenced in the special permit conditions. You're only going to have, I think it's 2 bedrooms.
My understanding was that hadn't changed overall with the renovation.
But the issue is that there's been no access to the property to verify that the conditions have been satisfied.
I understand that a lot of this arose during the height of the pandemic, actually at the onset of the pandemic.
Right.
And so there was a question about the opportunity to determine whether there were violations or compliance with the special permit conditions. Is that the reason why there still is this outstanding question, or are there known non-compliances with the special permit conditions?
The reason that we essentially don't know, we haven't been in the property to verify that the conditions have been satisfied.
In all this time?
In all this time, because the property owner would not allow us access.
I see.
And that was one of the concerns we had.
But I'm going to circle back again, because I'm just having trouble understanding. Even if the board's decision is correct so far as it goes, the board's decision expressly carved out any question about the zoning compliance, and zoning compliance would in and of itself trigger an independent need for certificate of occupancy, wouldn't it?
Yes.
So this decision could be perfectly correct, and so long as there remains an unverified question or unascertained, undetermined question about zoning compliance, this still would be in violation for occupancy without an occupancy certificate, independent of everything going on within this
I think I understand. Yes, I think what you are suggesting is that building code and zoning are different enforcement tools. If there's still a zoning violation, and there is one, we could still enforce it through zoning. I think that's what I think you are suggesting.
That's exactly what I'm saying. I mean, I'm just
agree.
having trouble, and even setting apart entirely the question whether the board's decision is right or wrong. There still is a need for an occupancy certificate. There still is not an occupancy certificate, and it's hard for me to understand the relevance of this entire action.
Okay. The relevance is that the critical code enforcement tool for the building inspector to verify compliance with all of the codes which it enforces, one of which is zoning, is the C of O. In other words, all of these other codes, zoning, fire code, all these various codes, they're all components in codes that the building inspector looks at and reviews to determine whether to issue a C of O. The C of O is that final act that says the property is safe and fit for occupancy.
Yeah, I know.
So with that,
So I'm still not understanding. So are you saying that the only trigger for a CO is in this building code?
no.
So then I go back to Chief Justice Green's question. Why is this relevant if there's an independent basis for requiring the CO?
In other words, the landlord could win here today, if we ruled from the bench or did that sort of thing, and still not be entitled to a certificate of occupancy. Is that true?
That's correct.
And still not be entitled to occupy in the absence of a certificate of occupancy, because even if it were the case that the building code doesn't require a C of O, the zoning regulations do require a C of O, and there is none.
Right. So, the zoning ordinance is independently enforceable for the building inspector. I think that's
I guess that's not this case. We have this case before us. It's properly before us so far as I can tell, and we will decide it. But I remain mystified as to the ultimate consequence of any determination in this case.
Right. Yeah, I mean, once again, our position is that
I understand.
the building code we have in front of us this case, this is what we've got. There was an application for C of O, and that's where we landed.
All right.
Unless there are additional questions, we ask the court to either remand the case back to the trial court to analyze the conflict, or reverse it outright and rule on the plain language of the code.
Thank you.
Thank you.
For the board?
Good morning, Your Honors. My name is Christina Gasson. I am counsel to the Board, Building Code Appeals Board, which is a arm of the Board of Building Regulations and Standards, which is responsible by statute and regulation to interpret all of the building code, and the Appeals Board is its arm where it reviews decisions by local and state building inspectors or authorities to determine whether there were errors or any other additions, interpretations, or failures to act on the building code.
The caption to the argument section, beginning on page 15 of your brief, to my reading, appears to concede error in the trial court's determination that there was a conflict between the two code provisions, but you don't include a concession to that effect in the text of the argument. You simply go on to suggest that any error was harmless. Do you or do you not view as error the trial judge's threshold determination that there was a conflict between the two code sections?
So our position is that the trial court found that both sections in question regulate the issuance of certificates of occupancy, and that they conflict, and therefore, in the instance of a conflict, that we can decide the board can decide which one applies.
Right.
We argue that it's not.
No, but you're not answering my question. Do you defend that view by the trial judge, or do you concede it's error because your caption suggests that it's a concession of error, but you don't say that in the brief, and I just want to find out what your position
We
is.
concede that one point that they are in conflict all the time is an error.
Okay, so then you go on to suggest that despite the error, there's no harm because the board's interpretation of the code provision was correct.
Correct. So there
And
are
you know where I'm going next, because I explained that earlier. Your brother gave an illustration that suggested that the interpretation of the board that all three conjunctive elements must be present produces an absurd result because the certificate of occupancy would only be required when a building is relocated, in addition to the other two. Relocations of buildings in the city of Somerville, I mean, I'm not to take judicial notice of such things, but I would expect they are somewhat rare. How do you respond?
So my response is that there are two sections of the building code that were analyzed by the Building Code Appeals Board and are relevant in this case. The first one is in Section 1 of the Building Code, and that is a section that's specifically entitled Certificate of Occupancy. That's the scoping language for the Massachusetts Building Code, and the board found that that was the section of the code that applied to this project, because it was discussing the alteration of the building and the change in use categories and the change in occupancy of the building. It found that while it looked at Section 34 or Section 110.1, it didn't apply to the specific project because it did not meet the specific prongs of that.
But in reaching that conclusion that it didn't apply, it applied the analysis that I've just asked you about.
Correct. It said that the Chapter 1
All three
control.
provisions must be present, right?
So it declined to, it looked at that section of the code, which was it's a section of the code that's called the International Existing Buildings Code, and it adopted that section. But it referred back to its main provision about certificates of
But
occupancy.
it only did that because it concluded that the other one was inapplicable here, because in order for that to be applicable, all three of those triggering conditions must be present, and all three were not.
That is correct.
And, well, it's correct that that's what they said.
Yes.
It's hard for me to adopt the view that that interpretation is correct. Now, you may argue, I suppose, that when both are applicable, they get to choose which one they want to apply, but I'm not sure how you get there. And that's not what they did in any event. And it's also entirely possible to adopt a view that both apply when they apply, and the second one, 110, applies when any one of the three conditions, triggering conditions, is present, which for reasons that have been laid out in the argument seems to be, and in the commentary, seems to be a more plausible, common sense, and rational interpretation.
There is information, there is sections in the scoping language in Chapter 1 that would say that if there is ambiguity in the provisions of the other codes, the other international codes, that we would rely upon the Massachusetts-specific language in the Chapter 1, which would refer to the use categories that we discussed about whether or not there was an alteration, whether or not it would change in use categories, whether the live load capacities would change, and that was what the board decided to rely upon. This is based on the 8th edition of the Massachusetts Building Code. Currently, we're in the 9th edition, and the board is moving to adopt a 10th edition of the Building Code. And since that time, it has
None of that applies
attempted
to this case, right?
Correct. It's not before this case, but it has attempted to address that ambiguity in the "and" by moving to an "or."
I get it, but we're stuck with what we have.
Correct. Okay. I'm sorry, I didn't.
I said we're stuck with what we have.
Correct. We're stuck with what we
We're dealing with the 8th edition, and so you're suggesting independently that the preamble language that says that where there's ambiguity in the international code
Correct.
provision, what is the ambiguity?
The ambiguity is that it's, the plain language of Section 34 says that it needs to be, though all of those conditions need to be met with respect to the location of the building or an alteration
Well,
in the
it
building.
can be read that way, but reading it that way leads to what some might characterize as an absurd result. And the commentary is available as an interpretive aid to avoid that absurd result. The language isn't as ambiguous as language I've seen in many other settings.
So the board's position was that because the alteration was such that there would be the same amount of bedrooms in the units, the same amount of units, the number of units wouldn't change, that it wasn't sufficient for a temporary certificate of occupancy to be issued. The discussions between the city and the property owner were discussions about they would like to have a certificate of occupancy, but they'd signed off on all of the building requirements, and they've signed off that the building met the requirements of 790 CMR, and it's in totality. The question before that they were looking to settle amongst themselves were the zoning issues, which are not before the building code
Right, and that
board.
was that seemed to me to be the principal basis on which the occupancy was denied in the first instance, which again carries me back to the question of why we're involved in this battle over the building code, but that's neither here nor there either.
That's correct. The Building Code Appeals Board doesn't have a position on any of the special
course you don't.
permitting or the zoning. Yeah.
Could I direct you to the section in Chapter 1 specifically called Certificate of Occupancy, Section 111.1? It contains similar language to 10.1 of the International Code, right? So it says, no building or structure shall be used or occupied. Here we're talking about new buildings or structures, right?
Correct.
Okay. And no change in the existing occupancy classification of a building or structure or portion thereof shall be made. So it has an and, just as the section that we're reviewing, until a certificate of occupancy has been issued. The board would not take the position there that you read the and to mean that both conditions have to be satisfied, right? That's just not a reasonable interpretation.
That's correct. So
So then why would we not read this, almost the identical language in 110.1 the same way?
in 110 and 111.11, it kind of lists the prongs. So it says, it discusses where there are different categories that must be satisfied.
No,
So-
but I'm looking at the preceding section.
Okay.
Okay, what triggers the requirement of a certificate? And there's the same and clause about change in existing occupancy classification as there is in 110.1. And the board's position was if it wasn't meant to be, if the section didn't require both clauses to be met, they would have used an or. But that is not how you can read this section, right? 111.1.
That is not how we read the section.
Okay.
We read it as it was specific prongs that needed to be met in the section,
In which section?
in section 111.1.
So can you repeat that?
Sure. So we would require that it would need to be changing from one use group to another. So for example, a restaurant to a multifamily property or another use
Well,
group.
then what's the meaning of the first clause? No building or structure shall be used or occupied.
I think you're not looking at the same section that Justice Shin is reading. So she's asking you about 111.1, not 111.1.1.
So I would say yes, we would look at that the plain language of that section. And unfortunately, I don't have it in front of me.
Okay.
So again, the BCAB found that the plain language of section 110.1 shows that there was an intent to change the existing occupancy in order to trigger the issuance of a certificate of occupancy. And it said that it wasn't applicable to the project because it was plain that it was an altered area of a building or a change in the existing occupancy would require a new certificate of occupancy. In doing so, the trial court affirmed the BCAB's determination that the new certificate of occupancy was not required for tenants to occupy the building because it contained an existing building that was hereinafter altered. While the trial court acknowledged and cited section 110.1, it did indicate that there was a conflict and declined to analyze it. Our position at the BCAB is that because that section is inapplicable and we would consider that we would defer to 111.11 with respect to the conflict, that if there was an error in the trial court's decision, it would be a harmless error because both the trial court and the BCAB analyzed the correct section of law that would be applied to this project. So we would ask that if this court were to affirm that decision, or if it were to find that there was an error, which we did concede that there was an error in indicating that there was a conflict, rather than a controlling provision of the building code, we'd ask that it be remanded on that fact, to determination of that fact only.
It's not a question of fact, it's a question of law, isn't it?
I'm sorry, a question of law, yes, a question of.
Why would we remand for determination of a pure question of law? Isn't that something that we are fully equipped to do?
You could do so in the alternative, correct?
All right. Anything further?
No, I have nothing
All
further.
right, thank you. The second case on our list for hearing this morning is case number 2022 P307, John Doe number 5267766 versus the Sex Offender Registry Board. This case is impounded. I'll just remind counsel to avoid reference to any of the impounded materials.
Good morning, Your Honor. I'm sorry.
Let's wait just a moment for Mr.
having trouble
Janai
here.
to Wait just a moment for Mr. Chennai to get to council table. We're moving rapidly through a very short list, but we can be a little more patient than that. Okay,
May I proceed?
you may.
Thank you, Your Honor. Fred Burkholder on behalf of DOE 526776. I guess I would like to say to start with that my brother had the privilege or the benefit of DOE 22188 being decided prior to his brief being filed, prepared and filed, and as a result, I believe he clearly states the appropriate test for whether substantial rights may have been prejudiced as a result of the application of Factor 2 in this case, which wasn't. So maybe that cuts to the chase, and I can tell you where I believe my client is. I don't think that the facts in this case clearly dictate that the classification was appropriate. And in that regard, I direct the court's attention to one of my other cases, which was decided subsequent to 22188, and that case being DOE 389586. And what the issue there was...
I wish we could get out of the business of referring to these by six-digit numbers.
I write them down.
I understand. Good for you. But it's, I don't know. I mean, you know, even the initials are difficult. But in any event, that's neither here nor there.
What was the number that you just gave?
389586.
389586, thank you.
Just to diverge, my esteemed counsel and I were trying to decide why nobody else wants to do this work, and it has a lot to do with these numbers. So
Right? I mean,
here's where where that case takes me. That was a case that I brought because Factor 1, mental abnormality, was applied without the benefit of an expert. And in the course of the argument, of course, we discussed 22188. When the decision came out, the case was remanded, and I pointed out because of the following. Not only is it the correct procedure, but two of the mitigating factors that the court found were sufficient to question whether or not the decision or the fact clearly dictated are present in my case. And they are low-risk assessment scores and highly restricted probation. And that's exactly what I have here.
I'm sorry to interrupt, but I just want to make sure I've got the facts right. My memory is that your client in this case had a moderate risk assessment score.
Yes, he actually had a 2 on his stable. Well, no, that's not true. He had a moderate, stable 2007. He had an average static 99. So
Is that low for those of us who are not in your business?
Oh, yeah.
Okay.
I mean, usually you get to a 5 or a 6 before you're talking about a level 2 or a level 3. They go up to 16. Am I right? 16? So a 2 is very, very low. And those are static factors. Those are factors that are going to remain throughout. So then the question becomes, all right, so what do we have in other mitigating factors? And if you look at the hearing examiner's decision here, there's only application of Factor 3, which is the fact that it was a child victim, and then the relationship, the public place, and the physical contact. Those are the same factors that were applicable in the case that I just cited, 389586.
wasn't there, I know you dispute this, but there were circumstances that could be construed to place Doe in a position of trust. And there was an escalating pattern of conduct that occurred over time before the offense.
I don't disagree. I do dispute it, but I think that a court could make that determination.
I also,
But can I
just as a framing point, so that you can understand how I'm viewing the case coming into this conversation. When I look at the role that Factor 2 played in the hearing examiner's analysis and ultimate conclusion, it doesn't appear to have been given independent significance. It appears as a companion to Factor 3, and not as the predominant contributing factor in that discussion.
I tend to disagree with you. I read it this morning. With regards to the risk of reoffense, the very second paragraph, specifically in terms of high risk factors, over a period of many months, 33-year-old blank, repeatedly and compulsively sexually assaulted and sent multiple sexually. I don't know how much more blatant it could be than that. And Just so that I can go back to the point that I wanted to make before with regards to the position of trust, the client in 389586 was also in a position of trust. He was a performance coach. And he also had 2 child victims. The only difference between him and this case is that he was a little older. But past that, and actually, this guy has more sex offender treatment and more support on the outside than the client in that case is. And let me say this, Judge, I'm not saying that that case is the end-all, be-all, but I took a look, as I always do before I come before your honors, and see where the cases have been. And unless I missed something, I only found one other case where Factor 2 was addressed, and that was a remand, and Justice Hershfang was on that case, and it was because there was a question of whether or not confrontation by a wife was a sufficient predicate.
And I understand, but
So past that,
just to go back to the point I made before, in terms of the weight that the hearing examiner in this case placed on Factor 2, the place I'm looking at is on page 67 in the addendum to your brief. And this is where Factor 2 comes into the discussion on risk
Are
of
we referring to
reoffense.
the hearing examiner's decision itself?
Yes.
Can you tell me what page that?
Well, I wish I could, but on the copy I'm looking at, it doesn't have page numbers other than the page at
What subsection is it, and I'll be able to find it?
subsection 1, risk of reoffense,
I'm looking right at it.
under discussion.
Looking right at it. That's what I just read from.
Yeah, specifically. So in the discussion, while inventorying the high-risk factors over a period of many months, the Doe repeatedly and compulsively sexually assaulted, penile penetration of her vagina, the 14-year-old child victim, and sent her multiple sexually explicit text messages and videos, and instructed to send him equally sexually explicit pictures and videos of herself, paren Factor 2 and Factor 3, treating both as triggered by that on a coextensive level.
Well,
If we take Factor 2 out of that, does it change anything? If we take Factor 2 out of that parenthetical, does it change anything
Well, certainly
the
it
hearing
does.
examiner said?
certainly it does, and what it takes out of it is the compulsiveness of the behavior. I mean, that's the whole idea.
Not really. I mean, he's talking about repeatedly and compulsively.
If you take Factor 2 out of that,
Right.
then you can no longer say that that behavior was compulsive. That's contrary to Dr. Hansen's articles. That's what the basis for 22188 was.
Okay, so excise the words "and compulsively" from that paragraph.
I don't think you can say, well, you can probably say repetitively.
What happened again and again? I mean, I think that's
Correct.
repeatedly.
It happened twice.
Well, it depends on what you call it, right? The text messages,
Those,
the
yeah,
videos.
those happened. He was charged with multiple counts. He ended up, I think, pleading to 3. Certainly, they did occur more
think
than
it was
once.
the
But those are
extent-
non-contact offenses that at best are going to give you a level 2. Under 496501, I'm sorry, there's with the numbers again, but
That one I remember.
that's what that case says.
I mean, one of the other factors present, I'm sorry.
No, go ahead.
One of the other factors present here was that he has not yet completed offender treatment. He has not yet had time in the community to establish or to demonstrate his ability to avoid reoffense. Now, none of those are sort of final. All of this stuff is a continuum. But when we get to this point in the conversation, I'm always reminded that he will have the opportunity to apply for reclassification, probably in the not-too-distant future.
But, Your Honors, with all due respect, the difference between a level 3 and a level 2 on the street is monumental.
I
Monumental.
understand that.
And when you have, under the factors, now one high-risk factor, and I understand you don't need any high-risk factor to be a level 3, but when you have 4 other applicable factors, and you have the amount of mitigating factors that are present in this case, and you have the only objective assessment instrument that exists says you have an average risk, and although I know it's not binding, it belies me how you can be a level 3 when you take out that factor. Basically, what you have is, and I'm certainly not condoning the conduct, but And I'm not going to say that all the other factors that that could be there are enough to put you over the edge. But this isn't that case. We all handle these cases on a regular basis. And the cases that end up being level 3s are the ones that are violence, the ones that are something where there's some degree of compulsion and or otherwise. I mean, the flavor that I get from the hearing examiner's decision here is that she thought he was a deviant. Well, guess what? You need to apply factor 1 to come up with that diagnosis, because there's no mental abnormality that's diagnosed here. My application for funds was denied because there was no alleged connection. So then to be replete and say, he's a deviant, well, show it to me. Because if you don't have compulsion and you don't have a diagnosis, then he's a guy that did something wrong. But when you put that connotation of deviancy on top of it, then sure, I can see why a court or a hearing examiner might want to say he's a level 3.
Well,
when you take it out,
but
he's not.
He's an adult who did something wrong with a child. That hasn't gone away.
Don't disagree.
And maybe there is an interpretation in which, or, I concede about the factor that there is no diagnosis of deviance, but I think societally we have determined that adults who commit sexual offenses with children are in a different category from adults who commit sexual offenses with other adults.
I couldn't agree with you more. But what differentiates the individuals is what they do thereafter. What I pulled out while Your Honors were speaking was, this is the Comprehensive Sexual Evaluation Assessment. And it says, Mr. Florio has demonstrated that he's engaged and motivated for treatment. He actively participates in primary groups. Mr. Florio has identified several personal goals for his treatment that are reflective of some insight into his sexual offending. It already appears that Mr. Florio is progressing in treatment and gaining insight throughout the comprehensive evaluation process, participation in a group.
It said in the, that he had timed out. What does that mean?
What it means is you're not there long enough to complete the actual, there's 4 phases of the treatment. It took me a long time to understand it until a psychologist had explained it to me. There are 4 phases. The first phase is basically introductory, to see whether or not you're really ready. Then you get put in intensive treatment. And intensive treatment is where you actually have to admit to your conduct. And then once you've admitted to your conduct, then you start to address how you can come up with ways in which to deal with those urges when they come forward. One of the esteemed psychologists that testifies in the SDP realm on a consistent basis, who I have now come to know because of reading his reports and the like, has the opinion that nobody can ever complete treatment completely, because phase 4 of the treatment originally was designed to be placed in an outside setting and you were going to go out in the community and be tested. That facility doesn't even exist anymore. So to say that you complete a treatment is an impossibility. Secondly, although I don't want any credit for the fact that his sentence ended, in the same respect, I don't know if you can penalize somebody because he didn't get sentenced long enough. I mean, what? So you're supposed to, and then factor 6 says, well, if you defer from probation and you want to stay there, we can tag you with that. It's like a catch-22. This guy's probation terms are significant. He's got the support of his family. He's got a college degree. He's got a plan. He's in touch with the right people, and his probation terms require him to do sex offender treatment. So if there's ever a guy that I'm going to stand here and say is not a level 3, this is the guy. Or at the very least, let a hearing examiner explain why, without that factor, that he still meets those high requirements. I go back to, and this is the last thing I'll say, I go back to the static 99R. That's an objective test. It's an assessment tool. It's used to a great degree in the SDP capacity. It's recognized by the board as being something that is available, and he had an average risk on it. An average risk. Not a high, not a median, nothing. An average risk. Average risk is you and I. I have nothing further.
Thank you.
If it pleases the court, David Shin for the board. When I started doing these cases, believe it or not, we were only on 3 numbers for each case, and I plan on retiring before we hit 7 numbers. But
Maybe we can come up with a different approach entirely. But,
I think the problem is,
again, that's outside the scope of this argument. Mr. Chennai, we have this conversation fairly regularly. You heard the last thing Mr. Burkholder said. why wouldn't we just send this back and let the hearing examiner tell us what he would do with factor 2 out of the equation?
I think, really, this case comes down to the diagnosis or the analysis in 22188. If you find that the evidence clearly dictates the level 3 classification, you should uphold it. If you don't find that, it should be sent back.
Well, there's a question. I mean, who is a better expert on what the hearing examiner would have done without factor 2 than the hearing examiner himself or
This is
herself?
true. This is true. But again, and again, one of my goals before I retire is I'm done with these factor 2 issues. But
There has to be a tail on these, right?
yeah, I think this is
more
one
in
of
the
the
pipeline?
I'm hoping this is one of the last ones. I don't track them, but they seem to be dwindling, and I know
Hearing examiners understand that they're not applying factor 2
they're not
anymore, right?
applying it
Yeah,
that way
okay.
anymore. In
Okay,
fact,
so-
the new regulation that's being drafted, and they hope to have in place sometime this summer, has rewritten factor 2 to exclude the first
and that
two
was-
sentences.
This goes back almost 2 years now, right? It was summer 21 that the Wilkins decision came down, right?
Correct.
May of 21.
It was April, actually, and truthfully, I've been arguing this, it started with Justice Milkey back in, I want to say 2013 or 14.
Right,
So-
but I mean, we had, well, I think actually it may have been in that July panel we had in 21 that we had this conversation, but in any event, there can only be so many more of these cases.
I think that most, there can only be a handful left because the cases have been working their way through the system. I know I have one.
Where is the board generally on their backlog for classification hearings?
Right now, I don't think there's much of a backlog. And I think part of the issue is that CPCS has been slow in getting attorneys to do these cases. So I know I have, the majority of my classifications coming up are reclassifications that offenders have requested. I think I have, in the next 60 days, 12 scheduled, and I'm one of 7 attorneys. So I think they're moving these cases along pretty rapidly. So I don't
There is
think,
capacity, in other words, if we were to send this back and just let the hearing examiner tell us directly, rather than having to engage in our own independent assessment of what they might have done?
you get to the point where, like with this case, he's already eligible for a reclassification. So even if the hearing examiner makes an amended decision, it goes through the Superior Court process again, that individual has lost their right for a reclassification. If you're going to send it back, a new hearing probably would be the better alternative, and just get this onto a new level.
Conversation has a Groundhog Day
It does.
character to it.
It does.
We've had this conversation before.
Yeah, I find when I take a case in the original classification, by the time I'm done with the classification, the Superior Court and the Appeals Court, I'm back on the reclassification within a couple of months of the Appeals Court decision. So it's in this kind of situation, I'm not sure it's advantageous
But
to.
that said, we still have the case before us, we still have the question, we have a job to do, you have a job to do.
Correct.
And I would think that it would be rather extraordinary, rather than the norm, for us to substitute our judgment for that of the hearing examiner on the question of how the combination of factors applies to an individual. I mean, in terms of how we generally approach all questions of administrative law,
Correct.
why would we put ourselves in that position except in circumstances where it was absolutely crystal clear beyond any reasonable possibility of divergent opinion?
Well, I don't think you would in that circumstance, and I think this case stands for that proposition that the board's asserting in its brief, that clearly that factor 2, the impact of factor 2, based on the facts of this case, really would not change the outcome if it were omitted, in the sense that the evidence is pretty clear. It's so much different than 22188, where that individual had years and years of positive interaction with the community. This individual committed his sex offenses, and they were heinous in the way he groomed this young lady, the way he dominated her life, the way he controlled her, in fact, going so far as to destroying her cell phone and giving her one that he paid for so he could control who she was contacting. These are things that show within a very short period of time that this individual, and he's only completed about, at that time, 18 months worth of treatment. So it's hard to say that he has all these positive qualities that would indicate that factor 2, the application of factor 2 adversely affect him to a degree where it was unfair to him. Again, if he had had a long history of like 2218 of positive interactions with the community. I think 2218 got a college degree, did years of therapy, admitted or acknowledged his wrongdoing, got a job as a pipe fitter.
Can you point us to any case involving factor 2, any of the factor 2 cases, where we affirmed rather than remanded?
I've had 3. I don't know the numbers off the top of my head.
That were affirmed?
That were affirmed by this court. One was right after 22188. One was a couple, I think was after the Wilkins decision when we were still using the prejudicial error standard, and I think there was one before that. But those 3, I think, were the only 3 that I had that were upheld. And basically what the court said is the evidence was pretty overwhelming in this case, and that the factor 2 was not going to make a difference if it was omitted from the equation. So
one of those cases was post 22188?
Yes, I think.
And the other 2 were before 22188?
One was after the Wilkins decision,
Right, but
and we had acknowledged that.
in relation to 22188, because, I mean, I found at least one case pre-22188 that affirmed, but it applied a substantial evidence standard once you excise factor 2, and I think in 22188, we clearly said that is the wrong standard.
Right,
And
and
we opposed a stricter standard. So you're saying there's one case post-22188 that
I
affirmed?
know there's one because when I came in, of course, the brief was written with prejudicial error, and I acknowledged that it was inappropriately applied in that factor, and that though 22188 did apply. And I know it came back that that panel upheld the classification decision. I don't have the number off the top of my head, but I do know I did get that decision. I want to say it was fairly soon after 22188 was issued, and I might have even had Judge Sachs on it. Because I remember reading it and I was surprised. And I'm always surprised when I win, so.
Can I ask you a practical question just about the process sort of flowing from the discussion about the petition for reconsideration versus the remand? After the initial decision has been made, well, I mean, at this point in the process, what is the current Mr. Doe being publicly treated as a level 3 sex offender? Is his information currently on the internet?
It is, because it was not stayed by it was never stayed in the Superior Court, and once the Superior Court issues its decision, a stay would be removed. Their option would be then to go back to the Superior Court and ask for a stay throughout the appellate procedure. If that was denied, they could, I think, go to a single justice to request it. But that, of course, didn't occur in this case. Again, I don't believe there was ever a stay placed on this. So throughout the Superior Court procedure, he was being disseminated on. And after the Superior Court decision, that dissemination continued.
Thank you.
So I think I've covered these issues fairly well in my brief. So unless there's specific questions, I'd be more than happy to rest on my brief.
Seeing no further questions, thank you both for your argument. The case is submitted, and we will be in recess.
Thank you, Your Honor.
Thank you, Your Honor.